Uber BVV Aslam UKSC 5 is a landmark case in UK labour law and company law on employment rights and the purpose of protecting people with a fair day's wage for a fair day's work. The UK Supreme Court held the Transport Corporation, Uber, must pay its drivers the national living wage and at least 28 days paid holidays from the time that drivers log onto the Uber app and are willing and able to work. The Supreme Court decision was unanimous and upheld the Court of Appeal, Employment Appeal Tribunal, and Employment Tribunal. The Supreme Court, and all courts below, left open whether the drivers are also employees but indicated that the criteria for employment status was fulfilled, given Uber's control over drivers. On the 16th of March, 2021, Uber indicated that it intended to violate the Supreme Court ruling by only paying drivers the minimum wage while driving, not when being available for work as the Supreme Court required. Yasin Aslam and James Farah, at the time members of the GMB union and represented by Lee Day alongside a number of drivers, claimed that they should be paid the minimum wage under the National Minimum Wage Act 1998 and receive paid annual leave under the Working Time Regulations 1998 while working as drivers for Uber. Uber BV, a Dutch incorporated subsidiary of Uber, argued that their drivers were self-employed independent contractors, and that it owed them no worker or employee obligations. Its contracts described the drivers as partners, and stated that nothing shall create an employment relationship between Uber and the partner. The drivers argued that this was a sham. Under the Employment Rights Act 1996 Section 230, anyone who personally performs work but not for a client or customer. The drivers contended they were workers. The Employment Tribunal unanimously held that the drivers were workers within the definition in Section 230 of the Employment Rights Act 1996 and were thus entitled to the minimum wage and holiday pay. The tribunal did not specify whether the claimants were also employees. As to Uber's tactics in pursuing its case, the tribunal observed, "This is, we think, an excellent illustration of the phenomenon of which Elias J. warned in the Kulwak case of armies of lawyers, contriving documents in their clients' interests which simply misrepresent the true rights and obligations on both sides." The tribunal gave the following reasons for arriving at its decision. The Employment Appeal Tribunal dismissed the appeal on 10 November 2017. In her ruling, HHJED stated, "I am satisfied the ET did not err either in its approach or in its conclusions when rejecting the contention that the contract was between driver and passenger and that was simply the agent in this relationship, providing its services as such to the drivers." Having rejected that characterization of the relevant relationships, on its findings as to the factual reality of the situation, the ET was entitled to conclude there was a contract between and the drivers whereby the drivers personally undertook work for as part of its business of providing transportation services to passengers in the London area. The majority of the Court of Appeal upheld the Employment Appeal Tribunal decision, so that Uber drivers are workers entitled to the minimum wage and paid holidays. The joint majority judgment said the following. 49. There is no dispute that autoclins puts paid, at least in an employment context, to the idea that all that matters is the terms of any written contract, with the exception of a document intended by all parties executing it to be a sham. Clearly, however, the case goes a good deal further. We regard as particularly significant Lord Clark's endorsement of the advice of Akins LJ2 tribunals to be realistic and worldly wise in this type of case when considering whether the terms of a written contract reflect the real terms of the bargain between the parties, and of the similar advice of Elias J. that tribunals should take a sensible and robust view of these matters in order to prevent form undermining substance. 50. We also attach importance to the approval given by Lord Clark to the conclusions drawn by Sedley LJ in this court from what he described as the critical findings of fact by employment judge Foxwell in the ET. Judge Foxwell noted that the claimants had no say in the terms on which they performed work. The contracts were devised entirely by autoclins, and the services they provided were subject to a detailed specification. The claimants had no control over the way in which they did their work. Judge Foxwell's conclusion from the facts was that the elaborate protestations in the contractual documents that the men were self-employed bore no practical relation to the reality of the relationship. Consequently, Lord Clark held, the documents did not reflect the true agreement between the parties. The ET had been entitled to disregard the terms of the written documents, insofar as